Hi, this is the 11th lecture of Principles of Company Law. We'll be looking at disclosure to members, and this normally takes place in the context of the annual general meeting, so it connects nicely to what we dealt with last week. However, there are two other elements to disclosure that we'll look at. So we'll look at the disclosure which takes place in the context of the annual general meeting. We will not go into any detail on annual accounts, financial statements, simply look at some of the differences between, let's say, a public company and a very small private company and a reporting exemption that can apply to them. But we will look in great detail at the director's report. This is something that lawyers often prepare, and you should be able to prepare a well-written disclosure report that complies with the law and meets the client's needs. We'll look at information provided upon request, and this is essentially an ad hoc type of disclosure where the requesting member has a proper purpose for the disclosure. And then we'll look briefly at the registers available to members and the public. And these registers are maintained on a rolling basis and generally available both for members and the public at large. So we have from this three routes to obtaining comforting information. Normally, the annual reports in a detailed annual report are the kind of thing that we would see in a listed company. Hong Kong is different. It provides very detailed annual reports even for private and very small private companies if they do not have a reporting exemption. The request for information by a shareholder for a proper purpose is something that originated in US law, migrated to Australia, and then is now found also in Section 740 of the Hong Kong Companies Ordinance. Lastly, the traditional UK method has not been discarded. So a number of registers of information on directors, members, charges are maintained and made available. So Hong Kong has three different methods of disclosure. This puts Hong Kong very high in the governance rankings internationally for the quality of its company law, but also means some significant burdens for the persons running a small company in Hong Kong complying with all of the disclosure which is required. The information provided to the AGM, as I said, will be both the financial statements and a director's report. So the financial statements we will not go into in any detail, but you should be familiar with some of the key terms used in accounting. And one of the most interesting and pervasive and important terms used is that the accounts must give a true and fair view. True and fair view, you can see how this is something that could take on different meanings in different contexts. So it's something like a test of proportionality that we use or a test of reasonableness that we use in law. So the true and fair view should be given of the financial position of the company, and that would be the balance sheet, and the financial performance of the company, and that would be the profit and loss statement or income statement. One shows the state of the company at that moment in time, and the other shows how the company has developed in the given financial year. It must apply with accounting standards. It would contain information on some of the transactions that we've looked at during this course, including financial systems. The corporate structure would be made clear by information about the parent of the in the group that is reporting. And then if the company does not have a reporting exemption, we would also have detailed information about the auditors. The director's report is something which, as I said, could very well be prepared by lawyers. Lawyers have traditionally prepared a lot of the reporting done by companies. Securities prospectuses in connection with an initial public offering or IPO are an area which are largely written by lawyers, and the annual reports of listed companies are also largely written by lawyers. So the director's report is not for a listed company. It would be for any company, although some private companies may have a reporting exemption. We have generally three sources of the law for the director's report. First of all, we have the trunk, which is in the main body of the company's ordinance in section 390. And 390 gives us some very open-ended requirements. So the director's report should present the principal activities of the company and other matters material to the members' appreciation of the state of the company's affairs. You can see how these are two standards which beg court interpretation because they are relatively open-ended and it's hard to say exactly what would fall under them. We do also have a couple of specific provisions, information on contracts with a person to manage the company. This is not a director's remuneration contract, but this would be something like bringing in an external management company, which is hired to manage, say, this company and a number of other companies. This type of management contract is highly unusual, and that's one of the reasons why you'd want it disclosed. And then also, remember, we talked a couple of weeks ago about the possibility, or actually the relatively straightforward prohibition on indemnifying a director. We do, however, have the possibility of indemnifying a director for the costs of defending themselves successfully in litigation, and that would be disclosed in the director's report. If the company is not enjoying a reporting exemption, you will be going into the business review as well. And the details of the business review are set out in Schedule 5 of the company's ordinance. This looks a lot like the disclosure which a listed company would give. Principal risks and uncertainties facing the company is going to be quite open-ended and difficult to understand exactly what should be said and what should not be said. And then events that have affected the company in the past year, again, we're going to have some discretion involved in deciding what is an important event and what isn't. An indication of the company's future business development, of course, does not have to give away secret plans, but it should comply with the law. So here, again, we're going to have some careful judgment exercised. Compliance with law, in particular environmental policies, must be disclosed. And then also key relationships with employees, customers, and suppliers would have to be disclosed. So this is a list which looks a lot like what listed companies would normally provide. And to my knowledge, only Hong Kong requires this much information from not only unlisted public companies, but also private companies as well. There is a dedicated regulation, which I'll upload on OpenEdX for you. You can look for that in the first folder of the course outline. And this is focused primarily on governance questions, allowing the members to grasp any conflicts of interest or special relationships between the directors and the company. So it would include significant transactions between the directors and the company, relationships allowing the directors to buy shares in the company, again, the indemnification provision for directors' legal fees, and then donations made by the company, which, if we're not receiving a quid pro quo, paying for a service or a product, there is the risk that payments of this kind could be bribery. And so by requiring that to be reported, the company then allows the members to scrutinize the activities of the company and help protect against corrupt behavior. The reporting exemption is something we will not spend a lot of time on. It is highly complex. I give you the basic outline of the reporting exemption here. So essentially we have two categories. We have a small private company which receives a more extensive and easier to achieve reporting exemption. And then we have a private company. And then we also have the possibility of a one-off exclusion of the business review under Schedule 5. So for a small private company, one of the things that it's a bit frustrating about the law is if you try to apply this, you'll see the interaction between the various provisions in the ordinance and Schedule 3, where detailed criteria are listed, is difficult and complex. Yet, the criteria are somehow quite artificial and arbitrary. So the term, the number 100 is used 3 times for completely different kinds of metrics. And it's a bit unusual to understand why a company with total revenue of 100 million would be treated like a company with total assets of 100 million, or like a company with total employees of 100. The number 100, has been used 3 times in completely different contexts. And it really does give one the impression that the lawmakers just couldn't find out the correct numbers to apply. And so they picked a uniform number out of the hat, which I said before is a bit frustrating when you're trying to apply these provisions because they are complex, they are intricate, yet nevertheless they are fundamentally arbitrary given the employment of the number 100 in very different contexts. So for a private company, we have the possibility of an exemption if the company is not embedded in a larger group, and we have unanimous approval. And then a private company, the members may by special resolution exclude the business review of the director's report for any given year. Because as I pointed out, the business review is quite difficult. And the governance aspects that are found in the director's report regulation are pretty straightforward and probably not as delicate as analyzing future risks, business prospects, and important relationships. So this is the annual reporting. And the annual reporting is what we'll focus on because it is something that you may very well be doing as a lawyer early on in your career. And then we, after this, go to our second type of disclosure, which is the disclosure upon request. Right? Oh, I'm sorry. The annual return is something that all companies will provide without exception. And the annual return is a report to the company's registry. And you can take a look at the contents here.